105601, State of Kansas v. Juan Lopez.
Your Honors, Michael Highland, representing the appellant Juan Lopez. I would like to reserve 3 minutes rebuttal time, if that's all right.
3 minutes is granted.
I don't want to restate the issues in the brief. I will give you a quick factual basis, if that's fine with the court. Basically, I do have 3 issues in my brief, but the last 2 are kind of put together. The first one is sufficiency of the evidence. That is what it is. The second one basically goes with the third one. It was a sentencing issue on aggravating and mitigating factors to determine a hard 50 sentence. There was, in my opinion, improper use of a prior acquittal of a homicide case that was used as an aggravating factor to determine a hard 50 sentence to be given. Basically, this case is out of Wyandotte County.
Could I clarify on your second issue? As I understood it, you were challenging the prosecutor's mentioning of the prior murder case in which Mr. Lopez was acquitted?
That's correct, Your Honor.
And I understood you were making a relevancy challenge to that.
Yes, I am.
Is there any other basis to challenge that other than relevancy? I didn't see that you had made an argument other than relevancy.
No, that's the argument that I was using. In that particular instance, Robin Wasson was the district attorney in our case, and she was also the district attorney in the prior case. And Judge Johnson in our case was also the judge in the prior case, so they both very well knew about the other case. This case involved 2 young men in one car with a little 12-year-old boy in the back seat. They were all members of what they called the SPV gang, which I think in Spanish means Southside for Life. They went to a gas station. While they were at the gas station, a car with 7 members from a rival gang, the F-13s or La Florencias, pulled up, and there were some discussions in the parking lot of the gas station. Then the Florencia gang, the other gang, drove off, and Juan Lopez was the driver of the car. In our case, he followed them out of the gas station. The young man in the back seat, the 12-year-old, he's kind of like a gangster wannabe. His brother is in this SPV gang, and he wants to be, but he's very young. And anyway, he gave a debriefing, deposition. He gave a 5-hour statement to the police where he told some untruths to begin with, but when it was all said and done, he basically named Juan Lopez as the driver of the car and Elder Molina, which is your 4th case today, as the shooter in the front passenger seat. And this boy, Max Palomino, was in the back seat as a passenger.
Mr. Highland, would you agree that if Max Palomino's testimony is believed, that would be sufficient evidence?
I believe that's why he was convicted, Your Honor. There were only 2 witnesses, he and Officer Pittman, who identified my
I understand that, but you're challenging the sufficiency, and as I understand it, your challenge really, for us to agree with you, we would have to find those 2 witnesses so incredible as to be have to be discarded.
That's correct, Judge. After our clients were following the first car, eventually they were supposing, according to Max Palomino, they were going to fist fight, they were going to box. In fact, when he gave his deposition, 3 times he said they were going to box. Twice he said that he didn't know there was a gun in the car until the gun came out the window. That's just prefacing what's to come. Eventually, the lead car turned off, and then our car had to make a U-turn and go after them, and that's what he did. That's what Juan did if Juan was the driver. If he's to be believed as the driver, he did make a U-turn and go after that car, which was probably the first thing he did wrong here. Second thing he did wrong was when he caught up to the car, the passenger, Mr. Molina, supposedly, according to Max, told Juan to pull up next to that car on the driver's side of that car. Juan, if he's driving, Juan pulled up to that car, and immediately the gun came out the passenger window and shot into the car, and 2 people were killed in the adjoining car. At that point, there's a lot of contention what happened next. There was a flight across the intersection. This was at 18th and Central in Wyandotte County, Kansas. A flight across the intersection where originally Officer Pittman, when he wrote his report out just 3 to 5 hours after this event happened, he wrote in there that the car proceeded across the intersection at a high rate of speed. Didn't mention that he identified anybody, didn't mention anything about the passenger or the driver looking at him. He just said it proceeded across the intersection at a high rate of speed. And then this police officer took chase, and they eventually caught up to the car. At the scene where they caught the car, the boy was apprehended. The passenger, the shooter, was tracked down by a dog. The police had a canine unit. They found him under a porch, and Mr. Lopez, if he was the driver, was never found at the scene or anywhere. He was arrested, I think, a couple of days later.
In that regard, as far as where everyone was at a particular time, during the trial, there was a map or something admitted, correct?
Yes, sir.
That's not in the record. Is it permissible for us to take judicial notice of a map of the area?
Actually, I don't know if anything was admitted on that. I think the prosecutor might have drawn some lines on a chart, because where they started and where they ended up wasn't very far away. It was just a few blocks when they stopped at the Armory, which isn't very far from where they started.
What does
So-
the record tell us about which way the car was facing?
When it took off or across the intersection? Which direction was it traveling?
I believe they were traveling east,
Okay.
and if I'm not mistaken here, the police car was on the north side facing south.
Okay.
So that would place the police car here and the defendants to the policeman's right. Okay? The police officer Pittman is the first. Well, let me do one thing real quick. There was a lot of evidence that came into the case, a lot of DNA evidence, fingerprint evidence. In fact, I think they put a bubble over the car and had over 400 fingerprints or partial prints taken from the car, both inside the car, front and back seat, and outside the car, door handles, everywhere. And when it was all said and done, there were not one single print that related to Juan Lopez. There was a lot of evidence about DNA brought in. Someone talked about it from the lab for a long time. None of that DNA evidence had anything to do with Juan Lopez. There were various police officers testified. They were involved in various aspects, like the chase, the dog search, the gun search. The gun was never found. The entire investigation for the case, all the taking of statements, the fingerprints of DNA, all of this, nothing tied Juan Lopez to this unit except for Officer Pittman and Max Palomino in the back seat, and those are the two I want to address real quickly. Officer Pittman was the driver of the police car. He testified that he was following another car who they suspected to be involved in some kind of drug activity. They pulled up at the intersection of 18th and Central, the lead car here, police car right behind it. The lead car kind of inched forward and actually crossed the white line where they're not supposed to be. They're starting to get into the intersection. Officer Pittman testified they thought he was going to run. They were going to be taking chase. It was at that instant that they heard the shots. They looked over and they saw a gun flash or several gun flashes out of the passenger window of the Lopez car into the car of the Florencia gang. As soon as that happened, within 2 or 3 seconds, this car was already across the intersection, Juan Lopez's car. I'm using his name throughout. Across the intersection, they crossed the intersection, went past one building, which was an auto zone, turned into the parking lot, went around it, came back out, and then proceeded up 18th Street to the Armory, and that's where they eventually were stopped at a dead end. Now, in the original report by Officer Pittman, he said that when he heard these reports of the gun, he looked over, saw what was happening. The car, at a great rate of speed, proceeded through the intersection. Then he had to take chase. That's about all he said at that point. But this was just shortly after the incident. Now, when we got to preliminary hearing, he altered his statement a little bit. He said that as the Lopez car was proceeding through the intersection, it slowed a bit. So he was able to see the car and see a little bit of what's there before, again, picked up speed and took off. Now, he didn't say that in his report, and I questioned him at length about that because usually police officers do the best they can, get the facts down right immediately after it when it's fresh in their mind. They want to get as much evidence. But when we got to jury trial, Officer Pittman testified that not only did this car proceed into the intersection and slow down, but that the driver, Juan Lopez in this case, looked at Officer Pittman, mouthed the words O-S-H-I-T, and then took off again. And at that point, Officer Pittman said he got a very good look at Mr. Lopez. And then the rest takes place again as before. Officer Forrest, who was the passenger in the police car, testified that as they heard the shots, they looked over at the car proceeded through the intersection going fast, it didn't slow. Officer Pittman had to somehow get around the car in front of him. He had to look and make sure there was no traffic either way in any of the four ways that it can come to be safe. He had to reach under the dash and flip 4 switches for the lights, and he had to reach overhead and flip a switch for the siren, all the while going around this car while he's looking at this car speeding through the intersection in 2 seconds. Officer Forrest also testified, and there were pictures admitted into evidence, that the driver's window was very heavily shaded. What do you call it? The film, the
Tinted.
tinted. I'm sorry. Yes, very heavily tinted, and that
But all of that was presented to the jury.
it was. Now, but this is part of me trying to attack Officer Pittman's testimony, since he is one of the 2 witnesses. Officer Forrest said that there's not only he, but he didn't believe anybody could tell who was in that car because it was so shaded. It was evening, it was November, it was dark, and it happened very fast. And he's not even the one, Officer Forrest is, who's having to do all this stuff with the police car and maneuver the car. So it was a little bit incredible, I thought, that Officer Pittman was able to identify him, especially after he had not put any of that in his original report, which would have been very important. He could have put immediately out on the APB, hey, we have a pickup order on Juan Lopez, but he didn't do that. It was a Honda. It was a Honda we're chasing. That's all he said. The only other witness that hurt me, or hurt Juan Lopez, was Max Palomino. Like I said, he said that they thought they were going to box because that's what they talked about at the gas station. Nothing was ever said about any kind of shooting or anything like that. Even when they were in the car, Max said that he never saw a gun, and he didn't think that there was ever a gun produced that Juan Lopez saw, and that the first time a gun came out and that he realized there was going to be a shooting was when it started shooting out the passenger window. So part of the evidence that I disputed was that Juan Lopez aided and abetted, knowing that there was going to be a shooting. He did pull up next to the car, but we don't know if it was to jump out and have a rumble or if he actually was pulling him up to set him up to shoot. The jury believed that that's what he was doing. That's really the facts. That's also the information I have about the sufficiency of the evidence. The only other thing I want to bring to your attentions, Your Honors, is the sentencing and the hard 40 aggravation. Since Judge Johnson heard the prior case where Juan Lopez was acquitted of a murder of a young boy, a young child anyway, and Robin Wasson was the DA on it, and we all knew about this ahead of time, but I was very surprised that Robin Wasson brought this up in her sentencing argument, that the court should use that, not because he was found guilty, because he wasn't, but just to show that the court already knows that this Juan Lopez is a bad guy, that he is a violent guy, whatever, because in the prior case, he wasn't the driver.
Was the prior case, did it involve a gang conflict?
Probably. The prior case, Juan Lopez was the shooter, but he was acquitted. I don't know for sure.
I understand the acquittal, but part of Palomino's testimony was it was Friday the 13th, and the F-13 gang shoots people on that day, and that the Serenas Por Vida gang shoots F-13 gang members also, and that's just what we do. And if the prior facts of the prior case show that there was that interaction, I can see some relevancy because the judge is permitted to consider all evidence.
I understand.
And if this individual was involved with a gang altercation before, wouldn't you say that's relevant to the sentencing decision that has to be made here?
I suppose you could call it that way, sir. Truly, I don't know if it was gang-related in the first case. I wasn't the attorney on it. It may very well have been.
But what we have is the judge is the one that's considering this, and the judge knew that it was an acquittal.
He did for sure, yes. And even put it on the record, he wanted to make sure that he wasn't using it to show that my client had been convicted of a prior crime. It's my understanding that on mitigating factors for the hard 50 sentence, which is what the state was asking for, they look at such things as prior crimes, bad acts that the defendant has committed, even maybe a diversion where he didn't get convicted, but he had to at least do a stipulation as to what the facts were, that what he might have done wrong to warrant the diversion. But in no case that I could find was it ever on a complete case that had been completely dismissed and he was found not guilty. I guess what I come down to is presumption of innocence. If you're presumed innocent till proven guilty beyond a reasonable doubt, is innocence the same as not guilty? I don't know. I mean, we have Lizzie Borden, we have OJ, who knows? But in this case, if they find you not guilty, you have presumption of innocence unless they find you guilty, so you must be innocent. And if you're innocent, that shouldn't be a factor in a hard 50 sentence. I understand he killed 2 people if he's considered to be an aider and abettor in this case. Even in that case, they didn't really show that he knew there was a gun or that he did the shooting himself. Maybe that's enough for aggravating factor for the hard 50, but I don't think they should have used it prior for sure.
Counsel, I see you're out of time. Let me ask my colleagues if anyone has any questions. All right, thank you.
Thank you. I really appreciate it.
Can you start by telling us what the relevance of an acquittal is?
Good morning, Your Honors.
Why not guilty, not guilty?
Good morning, Your Honors. I'm Ed Brandcart, Chief Deputy District Attorney from Wyandotte County. Judge, I agree with you that the district judge knew about the prior case. The sentencing rules allow him to consider evidence from a variety of sources if he thinks it's probative. The judge was very specific when he responded to an objection to considering it that he was not going to consider it as a conviction, but it was the elephant in the room. He was the judge that presided over a case just a few weeks before and understood what the evidence had been, but that the jury in that case had found the defendant not guilty.
If evidence that is not a part of the case that's before him for sentencing, I'm just curious. It presents an odd kind of scenario here because he's really allowing evidence he's privy to from another case that has nothing to do with this case. And I'm just wondering if he should have even, once he was considering that information that he was privy to simply because of his capacity in another case, if he's the appropriate judge to sit on the sentencing.
Yeah. Judge, I think that my response to that is that the prosecutor knew it. Of course,
right,
Judge
and the
Ernest
prosecutor
Johnson
brings it
knew
up because it wasn't she the prosecutor that prosecuted that crime also. Yes. So you kind of almost have this relationship between prosecutor and judge who know about the allegations in the prior case. There's an acquittal, and I would agree. I mean, an acquittal's an acquittal. How can that be considered? And then it just seems to me that it puts Mr. Lopez at a pretty significant disadvantage in that situation.
I understand your question, I think, and I'd ask you to consider that there was a third party to that relationship, and that was the defendant. He was present at the prior case as well as the one before the bench and knew about those facts. Counsel has just indicated moments ago that they all knew about that prior case. And so I don't believe there was any, if you're heading towards an unfair surprise type situation, everybody was on notice about it. I'd wrap up by saying
Well, it's
as
not,
he-
it's not really surprise. It's just the propriety of bringing in information that you're privy to from a prior case that has nothing to do and otherwise wouldn't come in unless the prosecutor put on evidence about it. The only way this comes in is because of the prior knowledge from the prior from the prior case, or the knowledge from the prior case. And I guess just get to Justice Johnson's questions. Why is it even relevant in terms of considering whether you're going, what sentence you're going to impose when it's an acquittal?
I think as Justice Johnson went on to explain it, the fact that he had been in a gang situation
But how do we know
a few weeks
that?
earlier.
What's in the record to tell us that? I mean, isn't one of the other problems that they bootstrapped a record from an entirely different case because of their personal knowledge? But is any of that information in the record in this case?
Not that I'm aware of, Your Honor.
So where's the foundation for probativeness?
Well, I don't know that we can unring Judge Johnson's recollection of what he sat on a few weeks before. What I think is more important is I can't find anything in the briefs that suggests that Judge Johnson factored it in making his sentencing decision.
And I interrupted you. Finish your thought about why the gang relationship and why that might have been made it relevant.
If it would support the evidence in this case, as the judge is sitting as a sentencing judge. Of course, there was no jury present. This wasn't an element being proved or that kind of thing. But on the issue of whether it was gang-related, it was probative to that. I'm not trying to suggest to you that it was heavily probative. It happened. It was something the judge knew, and he acknowledged that he knew it when he was asked about it. Certainly, there's sufficient evidence to support the conviction. Facts viewed in the light favorable to the prevailing party. Max Palomino, Officer Pittman, jury saw both of them, evaluated not only their testimony, but their demeanor. They were both subject to cross-examination and didn't wilt. There was some corroboration in the form of video from the gas station. I suspect that at least one of you is fully aware that this gas station is across the street to the north from Fritz's, and that this intersection is a couple of blocks south of that gas station, and then the armory that's being spoke of is another couple of 3 blocks on south of that intersection. The testimony, to get to one question, the evidence in the case was that the Lopez Molina Palomino car drove into the oncoming lane. They were eastbound. They drove into the oncoming westbound lane to pull up alongside the Diaz car. I don't think that there's other things that I wish to try and expound upon, but certainly if you have questions, I'd take them. Otherwise, I'd submit it on our briefs.
Did the trial judge, after prosecutor mentioned the prior case, and the trial judge said what he said in that regard, did he ever mention it again? I know she brought it up again to reiterate that she wasn't using it as an aggravating factor, but did he ever mention it again?
I don't find in the briefs any mention of his discussing it when he delivered or announced the sentence. No, Your Honor.
Any further questions? Thank you, counsel.
Thank you.
We reserve 3 minutes for rebuttal.
I would stand on the brief at this point unless there's any questions.
I have one question. With regard to what the court said on the record, my recollection is that the judge went through sort of the thought process with the weighing, indicated that there were mitigators, the fact that he was an accomplice and the fact that he's a young age, but the killing of 2 individuals as an aggravating factor was not outweighed by those mitigators, and I didn't see anything in there where his prior trial or anything formed part of that discussion or that weighing it. In other words, the judge said on the record that the court was weighing what would be appropriate factors. Would you agree with that?
At that point, he did not bring up this issue again. The only thing I was appealing on was the fact that he had overruled my objection in the first place and allowed it to come in. Thank you, Your Honor.
Do we have any further questions? All right. Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. Turn to the